Hi, it's Chris Jackman. Welcome back to a Father's Rights podcast. In today's episode, I'd like to talk to you about relocating with children in the course of a divorce or even after a divorce. And I'm bringing this up because for most of the country right now, depending on when you're listening to this, it's back to school season, and we've had a lot of people call us recently who would like to relocate with their children right before the school year starts. And since it's such a prevalent topic that I'm seeing come in with calls, I want to talk to you about that today so you have a solid understanding about how the relocation will go with a child or with your children. So first of all, if you let's for example say you get a different job offer, as one of my clients recently did, and the job offer requires you to move either out of state or out of the school district, there are some concrete steps that you absolutely must follow to be able to do this. You cannot, unfortunately, if you have either an ex-husband or an ex-wife who shares custody or even has a very small amount of visitation rights with your child, you can't just up and leave and move with your child without giving the court system notice or giving your ex notice. And unfortunately, one of my clients did this, and having to kind of go back now and retroactively salvage this case is very difficult. It's often much easier, like most things in law, if you can be proactive and work with a lawyer before an action's taken rather than letting something happen and then going back and trying to kind of clean things up and get things situated. Because now we're at a point in this particular case that I'm referring to where it's really difficult. It's really difficult to, once the move has already taken place, to try to unwind it, which is looking like it's going to happen. And I want to be very clear about this, that yes, as crazy as it may sound, the court system and the judge in a case has the authority to force you back to the place that you were living before. So just to give you an example, if you're living in Los Angeles and you get your dream job in New York and you've got a custody arrangement with your husband or your wife or whatever in Los Angeles, and then you just up and move to New York without giving any kind of notice, even if you were to buy a home and put down roots and start this new job, it is, as crazy as it may sound, it is entirely possible and legal for the judge to order you back to Los Angeles, to where you were, and you will have to figure out what's going to happen in terms of where you live when you move back and what kind of job you have. So you can imagine the level of disruption this can cause in someone's life if they just get the idea to suddenly move and put down roots, right? Because now you've got to quit that job, you got to sell that house or break the lease or whatever and go back to where you were. So the consequences can be really, really severe. And that's why I'm pleading with you, if you are going through this or if someone you know is contemplating doing this move or making this change, that you take the steps now to lay the foundation and do the legal process in the right way and the timely way, so you're not stuck in this position where you may in fact have to backtrack and try to unwind what you've done. Because again, there's just no way to avoid that. And unfortunately, you could have the best, the best lawyer in the world and the largest law firm in the world helping you, but that's not going to change anything if the judge makes a decision that's adverse to you. So what do you have to do? First things first is you really need to be able to come up with strong reasons why the move is in the best interest of your child or children. And what I often see is the argument is, well, I as the parent got a great job offer and therefore it's going to benefit my child if I'm able to move because I'll be able to whatever, build them a bigger home or buy them a bigger home or take them on more vacations or put them in private school. And that argument works to an extent, depending on your situation, but it's kind of the wrong frame or the wrong lens by which to view this case. So even though it very well may be true that this new job offer or whatever it is it's leading you to move or want to relocate is great, you need to think of it and you need to frame it to the judge in a way that is in the best interest of your child, because that's the standard, the legal standard the judge is going to look at when making a determination on what to do with your case. So you shouldn't come at it with the viewpoint of, well, I've got this great job offer, I'm going to double my salary and get this great place, or get this place that's much better than where my child was living. You need to frame it in a way that, okay, it's in the best interest of my child that we move because. Now, it may be that part of the reason for your move is that you want to remove your child from the current environment that they're in with your ex or with whoever is co-parenting. And those are valid reasons too, and you need to bring those up. But here's the thing, is you have to, and every county is different, so I don't want to give you an exact day number depending on what county you're in, it can change. But typically what I see is somewhere between 45 and 60 days notice. So 4, 5, and 60. So in other words, even if you give a month's notice about this move, that may not be enough. I've also seen cases where, my client did give a 60-day notice and the other party, the other parent, waited until day 70 to respond. And there was this whole court hearing about whether, the 60-day deadline should be enforced or if there should be some generosity allowed. So my advice to you is, even if in your particular county that you're in, if it's 60 days, that you A, wait a little bit before you do it, and that B, you don't just say, okay, it's been 61 days, my ex only had 60 days to object or respond to this plan I have to move, I'm good, I'm in the clear, I'm just gonna move. I think that's a mistake. What you're actually much better off doing, because who knows, it very well may be that the way you notified, the legal term is served, your spouse with the documents wasn't proper. It may be that these people, your ex is just sitting on their hands and not doing anything. So what you need to do to proactively protect yourself is then go into court and get what's called a default. All that means is the word default just means they didn't do something. So if you can go into court and say, Your Honor, I properly gave notice to my ex 61 days ago, he's done or she's done nothing in that time to file an objection to my moving, I need for you, Judge, to sign this order saying notice was given, this person's now in default, I'm good to go. So now you've got the official blessing, so to speak, of the judge. Without that, even again, 60 days pass, 90 days pass, there's still a possibility that the judge could say, I know this person was 10 or 30 days late, but they eventually did file a response or an objection to your move. I'm gonna put a pin in this, prevent you from moving until I hear from this other person about why you should not move. So again, file the proper documents, wait a little longer than is required of you, and then number 3, if they don't respond, immediately go into court to get that court order saying that basically this person hasn't done anything, let me go ahead and move. So the question is going to be, what happens if they object? Because they probably will, right? It's not real likely that your ex or the father or mother of your child is just going to say, okay, good, go. You're free to leave with my child. I'll never see them again, or I'll just see them whenever you feel like letting me see them, right? Because what's going to have to happen is you're going to have to really modify and change the current plan that you have. Right? And most parents don't want to do that, right? They kind of like things the way they were. So in the event that this parent objects, they very well may hire their own lawyer to file documents. Well, now, believe it or not, you're right back into the court system, which you probably were in before when you were going through your custody issue or through your divorce. And you got to view this like a totally separate new case now, which it is. You're going to have some deadlines to meet. You're ultimately going to have a trial, probably 7 to 9 months out from when you put that notice in, and the trial will be solely on the basis of, is it in the best interest of your child to move? Now, I mentioned at the outset of this, that's the lens you got to view this through. That's what you got to keep going back to again and again and again. But you got to do it, right? And you got to think of it that way, and you got to come up with ways to persuade the judge that this move is going to benefit your child. So you might be wondering, well, how do I do that, right? And a common example could be, well, I'm moving to an area that has much better schools. It's a better school district. Well, U.S. News and World Report has pretty exhaustive rankings of schools, so that's an easy way to come up with a reason, right? Is, hey, school ABC has a much better school system. It's highly ranked. Here, Your Honor, are exhibits, documents showing why this is a good school, right? It may be that you are moving into a bigger home and that your child's going to have their own room, right? Having something that shows that, obviously if you can get the Redfin or the Zillow listing and then show that there's extra bedrooms for your child and they're not going to be living with 5 other people in the same room, that's a strong argument, right? And like most things, if you can have others step up for you and write statements as to why this new environment or this new city is better for your child, even better. I would strongly encourage you to do that, because what I often hear from judges is that, and this oftentimes has been communicated to me kind of off the record, is that, a lot of times both parents seem pretty good in terms of how they present and how they testify. And so a lot of times the judge will just say, well, the parents are kind of a wash. They kind of cancel each other out because they're both persuasive and sincere. So then it comes down to, okay, which side has the better and more witnesses who can actually step up and talk about why this relocation is in the best interest of your child. Now, the last thing I would say is that if you can find these folks, great. You want to hear from them, you want to get statements from them, but it's not to say that you don't want to point to and highlight the adverse conditions that your child may be living in now. So if there's things that are not going well, like if school is not going well, if they're getting bad grades, they're having behavioral issues, you obviously want to bring that up and just say, Your Honor, the status quo, like what we're doing now, just isn't working. And that maybe a change would be good for my son or my daughter. But again, I think that you have to constantly view it through that lens, because it's often really hard for people to think that way, because they're often solely thinking about why it's good for them or why it's good for their career to make that move. And again, you really have to view it through the lens of what's in the best interest of your child. So I hope this has helped today. Again, we're in depending on when you're listening, when a lot of kids are going back to school, and this is when I see this the most. And if you're listening to this in August, frankly, the time to have done this, to make this move or to try to make this move, you should have been filing court documents probably in January or February of this year, because then at least you probably have a trial date by now. Because I think that's another problem I see that people have, is they really underestimate and discount how long it takes to get into court. The court systems, no matter where you are, really backed up, and you're not going to get a trial in a month. It's often 7, 9, maybe even 12 months from the day that you file. So the more proactive that you are and the more that you're setting this out, in fact, if you're listening to this in August or September of this year, I would say that you should probably file now with the hope that this time next year, you can make that move if need be. But these are the things you need to be thinking about, to be proactive about before you make the move. As always, if you have questions, if you want to talk about your case, feel free to give us a call. We would love to hear from you.